All right, let's get started. As you all know that there are changes in the way that we would be doing our CAP filing this year. So our team here at Codem Law Firm wanted to put together a presentation and walk you through what are the changes and what we know and don't know at this point in time. Currently, the team, everyone on the call are being muted, and we would be opening up the lines for question and answer sessions once we are done. Once I'm done going through the presentation. So let's get started. So to give you a background, what happened was in November of 2018, the Department of Homeland Security announced that they would be making some changes to the way how H-1B cap is done. This was published, the initial proposal was published in the Federal Registrar, the place where something is confirmed, the rule is confirmed, in December of 2018, and they clarified certain rules and published it last week. Now, when we are looking at the cap, there are two main changes that we are looking at. One, the method of doing the lottery. So as you know, we have 20,000 master's quota and 65,000 general quota. Before 2019, the way the lottery used to be done was the master's quota would be done first. That is 20,000 applications would be picked from the lottery, and then the 65,000 is executed. As of last year, they changed it in such a way that the general quota is done first, and then the all the master's applications are filtered out, and then the 20,000 is run. Now, this DHS believes that this gives a master's students 13% more chance of being selected in the lottery than the general category. Now, this, as I said, this was implemented last year, and they're going to keep doing this. Now, the second thing is the pre-registration process. So USCIS, what they are saying is, hey, there are too many applications that are being sent in during the cap, and it is taking too much resources from their end and from the end of the petitioners to handle this. So they suggested this pre-registration process wherein the petitioner would pre-register. When I say pre-register, basically come into the electronic portal, provide information about the beneficiary who they would like to apply for CAP, and then once the lottery is done just on the electronic registration, and only the applications that are picked in the pre-registration process, they would be sending the file, the G28, the I-129s, the LCAs, and all the fun stuff to USCIS afterwards. So basically what they're saying is, hey, we wouldn't be getting, USCIS won't be getting hit by 300,000 physical applications, but we will be getting hit by only 65 plus 20,000 application. But during the pre-registration process, it's free for all, everyone come in and enter. Now, when I say free for all, that was a tongue-in-cheek. They're charging $10 per registration, right? Now let's go through the process as to what the changes are. Now, like I said, during the pre-registration process or the initial registration process is opened from March 1st of 2020 to March 20th of 2020. During this period, the petitioners would be, or through their attorneys, would be electronically be submitting registration per beneficiary that they want to file. Now, once a sufficient number of registration is received, then USCIS will be running the lottery, and only the selected registrations would be allowed to file the petition. Now, to do the pre-registration, these are the information that we are seeking from the petitioner. The name of the petitioner, including any DBA as that is doing business as, the FEIN, the address of the petitioner, the authorized official. Authorized, when I say authorized official, we mean the person who would be signing the form. So it could be the owner of the firm, it could be your designated HR person, whoever that might be. The email ID of the associated official. Now, this is very important. The email ID is critical. So, because you would be registering on the portal, on the USCIS portal through this email ID and the petitioner's phone number. But I'll go through the process in detail, but detail in the next few slides. Now, the information that is required from the beneficiary are the beneficiary's first and last name, gender, date of birth, country of citizenship, passport numbers, and whether they are from going to be doing masters or bachelors. I request the team here to kindly pay attention to those fields marked in red because there are some nuances that we need to take care of here. Please remember, the way USCIS has entered the regulation in the Federal Register says that only the beneficiary picked in pre-registration can apply. So let's take an example. A petition company XYZ Inc. applies for Jane Doe. Jane Doe's application is picked through pre-registration. They expect the application that is sent only to be only of that of Jane Doe. They don't want a John Doe's application come in. So it's very important here for us to make sure that the name that is being provided for the beneficiary is accurate. Lot of Southeast Asian passports have only the first name and the last name, and there is no concept of middle name in our Southeast Asian passports. However, we see in our law firm that it is being a common trend for beneficiaries to claim a middle name. So the name that is being provided, I reiterate, has to be per the passport. Now, when we are talking about dates, let's remember we are looking at dates as an MMDDYY and not a DDMMYY. The amount of time that we have found mistakes with this is very high. And given that we are going into a territory that is completely unknown to us, we don't know how exactly this is going to work. I would, abundance of cautions is required when we are entering the data. Passport numbers. This is a good time for you to check with your employees to make sure their passports are up to date. That is, the passports are not expiring in the near future. And if they are, now is the time to apply for one and get them renewed. And this is my concern behind it. We enter a passport number and it expires before we can file the petition. This causes two things. USCIS may say, hey, the passport number is different, so we're not going to accept it. Two, the filing may be incomplete. So please, now is the time that you send out HR, send out emails to your employees saying, hey boss, take a look at your passport to see if it is expiring or not. And if it is, go ahead and renew it. Now, when we talk about bachelor's or master's, as you know, there is a bachelor's quota, the bachelor's quota or the general quota, and there's a master's quota. At the time of pre-registration, it is not required for the beneficiary to have completed their master's, right? They should be completing the master's by the time we actually send the paperwork in. But at the time of pre-registration, it is not required. So it is important for us to know when a person is graduating to make that determination. Other places of concerns would be whether, again, let me take a step back and explain. A person is qualified for the master's quota only when they are from an accredited school from ACI-ACS. It's a non-profit. It's a non-profit school, non-profit or a public school. Now we know that over the last few years, a lot of schools have lost accreditation. So we need to know which school they are coming from, because this is important for us to make a determination whether the person will be qualifying for a master's degree or a bachelor's degree. And we know that some schools were later found out to have lost their accreditation, or they are for-profit universities, right? There are a lot of for-profit universities that people are joining in, and it's very important for us to make sure that the beneficiaries who are graduating from these institutions are qualified for the master's quota. And the reason for concern is this. They apply for master's quota, and then we realized, oops, the college that they graduated from does not qualify from the master's quota, then USCIS will deny the petition. We have seen this in the past, and like I said, with abundance of caution, it's better to be more careful than not. Now, given all these timelines and time frames that we've been throwing at everyone, we wanted to put together a timeline as to what we are expecting between when and when. So between now and March 1st, we are looking to collect all the data and initiate the cases for beneficiaries for whom a petitioner is interested in doing the pre-registration. So the information that I mentioned in the past couple of slides, now is the time that we start collecting it. Between March 1st and March 20th, we would be doing pre-registration. Again, the pre-registration is electronic, and the cost of pre-registration is $10 per registration. Now, ideally, we would like to file the LCA between March 21st to March 31st to keep it handy. There's a story behind it. In January of 2019, if people recall, we were not able to file LCAs through iCert. And one of the reasons what happened was there was a pre-registration system that was opened on iCert for H2As and H2Bs. The system collapsed within 2 days, within 2 hours actually. And it took USCIS and DOL quite some time to bring it up. Now, what they did in 2019 of January was they turned around and said, you know what, we are not able to bring the portal up, go ahead and file it manually. So, like I said, we would like to keep file the LCAs and keep it ready. Just in case something happens, we have a backup plan. The other reason for raising the LCAs would be that you have to remember a student who is going to qualify for CAP-GAP. They qualify for CAP-GAP only when an application has gone into USCIS. That is, a person has been pre-registered and you send the physical application to USCIS, only then a person qualifies for CAP-GAP. Now, if anyone's STEM OPT is expiring in the first week of April, I highly recommend that we go ahead and file their applications as soon as possible so that they qualify for CAP-GAP. Now, that said, by 31st of March, we expect the results for pre-registration to be announced. That is, USCIS should be telling us, okay, these are the people who got picked in the pre-registration process. So they are supposed to announce it between March 31st and April 1st. Now, unlike the prior years, wherein we got just 5 days to send in the physical application, USCIS is saying that you get 90 days, that is time from April 1st to June 30th to send in the physical application. Now, if you recall, we did not have to provide the location where the beneficiary is going to be working during the time of pre-registration. So an advantage that we have right now is if you think the project is changing or the person would be moving to another location, we can time the filing of LCAs if needed and file the application. Now, once the application is filed, people whose application has been picked, they go through CAP-GAP until 9:30 only, that is until 30th of September only. And basically it's a wait and watch to see, are they going to issue RFEs, what kind of RFEs, all the murder mysteries. Starting 10/1, a person on CAP-GAP does not qualify for does not have CAP-GAP benefit. That is, while they can live in the country until a decision on the case is made, they are not authorized to work. And people whose applications are picked, they would be starting their H-1B. Now, there are various scenarios to consider. Now, the first one, OPT and STEM OPT, that ends before April 7th. Now, like I said, to qualify for CAP-GAP, it is required that the person's application, the physical application, goes into USCIS. Just because a person's application gets picked up in pre-registration does not qualify them for CAP-GAP. So it's important to file those applications immediately so that they qualify. Technically, the regulation says that to qualify for CAP-GAP, the applications have to send in within the first week of April. Now, USCIS has not come back yet to say, would they extend this feature for the entire 90-day period or not? But like I said, since it's the unknown, we would like to file the petition earlier. The graduation date and the graduating school is important, as we discussed earlier. We talked about the prior filing of the LCAs. So again, it I know that one of the concerns that a lot of employers have is, hey, if we file the LCAs ahead of time, we will lose a couple of months on the H1 validity period. But if in the bigger scheme of things, 2 months is really not, 2 or 3 months is really not going to affect it. We are trying to make sure that we are ready to file an application in case something happens to the portal and we are not able to register. Now, let's say everything goes fine. We can always file another LCA. That is not going to cost us anything, but it may not be a bad idea to file the LCAs and keep it ready just as a backup, right? Now, determination of whether it's going to be a change of status or counselor process. One of the things that we noticed this year, that is when I talk about this year, I mean the fiscal year 2020, was we filed an application for a change of status, and at the time of RFE, especially when it came to situations such as CPT, a lot of petitioners came to us and said, hey, can you change this to a counselor process? We can, in the sense that we can request USCIS to say, hey, can you please cooperate and make this petition a counselor petition? And it's up to the discretion of the USCIS officer to accept or not. Some did, some did not. Now, it would be a worthwhile idea to take a step back, take a deep breath, and determine whether you want to file a particular application as a change of status or as a counselor process. While the F1 memo is on hold due to the injunction, I still recommend to take for CPT students on CPT or students who have done more than 1 year of practical training, that is OPT and STEM CPT combined, to consider filing your applications as counselor process, because if the injunction is removed, then we go back to the memo as it stood, right? So that is something to consider. Now, unfiled applications. So the way the regulation is being registered in the Federal Register says that an employer may be subjected to penalty if they are not filing applications that were already pre-registered and they are considered a repeat offender. Now, what that means is applications have been filed for the pre-registration. It's been picked, and for whatever reason, the petitioner is not actually filing the H1. Now, we don't know under what scenarios you're considered repeat offenders, but that statement is clearly written in the Federal Register. So you need to start thinking of having documentation in case USCIS comes back to you and say, hey, you applied for 10 pre-registration applications, 7 got picked, but you filed only for 1. Give me reasons why. So it is necessary to have it documented. Now, factors to consider. Now, because it is going to be a very limited set of documents that is going to USCIS, one of the things that the team here might want to consider is the filing of a complete application. That is, when I say a complete application, provide everything that covers right to control, specialty occupation, maintenance of status, up ahead of time, availability of work much ahead of time, so that you're basically forcing USCIS to say approve the petition instead of an RFE. Now, I have to say this: while it is an adversarial system, an RFE should be issued by USCIS. USCIS has not clarified anything about whether they will be issuing RFEs or not. So it may not be a bad idea to file a complete application now that we have 90 days to really file it, right? So That is important to consider. The other one is right to control. So when we're talking about right to control, that includes availability of work. So if you have vendors in the middle, we need the MSAs and SOWs between each layer. I've gone on record before and I'm going on record again. Please be very careful when you work with implementation partners, because implementation partners usually do not give the contracts, and that leads to a denial later. While they say they would give it now, we have seen time and again that they have not. So please be careful. Specialty occupation. So we talk about educational requirement. There is a case law, Lexis versus Rex, that says that a computer science degree is not required for a person to do the job of a software developer. But we're still seeing RFEs to the effect saying that, hey, this person has an electronics degree. How is this person qualified to do a specialty occupation? So let's take the way that we do specialty occupation, and be ready to answer that. Maintenance of status. This is specifically important for students. Students have to show that the terms and conditions for their 983s, their OPT and STEM OPT period is met. That is, they have worked for a certain number of days. They have not been without a job for more than 5 months in total. They have not done more than 1 year of CPT and OPT. Those things are considered. Now remember, when you do some files and application as a counselor process, you take away the question of maintenance of status away from USCIS's hand. So that's one of the reasons why I said earlier that consider whether you should be filing a petition as a change of status or a counselor process. Now, the other maintenance of status issue comes up is for H4 beneficiaries. So at the H4 beneficiaries have to show that the associative H1 that person has maintained their status. So we would need their marriage certificate, we would need the pay stubs of the H1 beneficiary, their H1 approval notice, and their passport. Now, I have been crying about this quite a bit, but I've been considering opening a travel agencies off late, because everyone wants to travel. It is either their wedding, it's friend's wedding, it is an emergency, but everyone wants to travel. So let's talk about travel. Travel during pre-registration is fine, but I request that the student comes back in before their application is sent in, because if a petition is sent in as a change of status, and the person leaves the country at that time, then the petition can be considered to have been abandoned. There is no regulation as such to that, but it's more of how USCIS is interpreting the existing regulation. So you travel when the change of status petition is pending, the likelihood that you're considered abandoned the petition is high, and there's no turning back from that time. Now, travel during cap gap. Now, cap gap is an associated benefit that is given to a master's student. So when the person travels and during cap gap, the CBP officer has every reason to say, no, you cannot come back in. And the reason is so. One, a person has graduated. Two, the person has already completed their OPT or STEM OPT at that time, and it is not required. Basically, they've gotten all the benefit of the F1 visa, and that's not required for CBP officer to let them in. So please be careful about students wanting to traveling during cap gap. In my opinion, no one should be traveling unless it's absolutely necessary. But like I said, everyone wants to travel. So as we know, this process is completely new to us, and there are a lot of unknowns that are associated with unknowns associated. One, filing centers. Right now, we don't know where the CAP petitions would be filed based on the petitioner's location. So we don't know for sure if the Texas employers would be sending their petition to Texas Service Center. We don't know whether Illinois employees will be sending their petitions to Nebraska Service Center. It, this will play out. Like I said, RFEs should be expected. I would expect RFEs because if they don't give us RFEs, it is very contrary to the adversarial system that we have in the United States. But we don't know the type of RFEs and if they're going to come up with something creative. Students on CPT. Like I said, students on CPT, if something happens to the injunction, for whatever reason it is lifted, and it goes back to the prior memo, it may be considered that the students who are on CPT have lost their status and have not been maintaining their status. So you need to be very, very careful when CPT is in question. I know the other favorite question that everyone asks is premium processing. Is it allowed or not? At this time, USCIS has not said one way or the other whether premium is going to be available or not. As of today, it is available, but usually USCIS makes a determination beginning of March whether to allow premium or not. So it's a wait and watch. Now, given that, we wanted to talk about our firm's approach to the filing. Now, as you know, we take our applications, the cases are initiated through our firm's portal. It can be done right away. But if you give us time until Jan 20th, you would be able to do you will be able to initiate, do a bulk upload on the portal, that is basically create multiple cases at the same time. We require that the beneficiary associated to the portal complete their entire profile. That means they give us their name, their passport, their transcripts. Everything is provided to us up ahead so that we can do our due diligence to make sure the information provided is accurate. Again, we would like to reiterate that the portal is completely secure. Only the employer would be able to view the beneficiary's document, their employer beneficiary's document, and no one else. And the data does not leave United States, does not leave North America. We also need a confirmation on the USCIS email, petitioner's USCIS email. If you recall, we talked about the HR's email ID. We need you to go ahead and create a user ID password on USCIS website and confirm the USCIS email ID that we have given. And the reason is this: once we submit, the HR would be getting an email saying to confirm, and they need to hit submit for the application to go through. So it is very important for us to make sure that the email ID on the file is an accurate one. Now, we talked about the filing of LCAs between March 21st and 30th, but if you prefer, we can start filing the LCAs from March 1st onwards. We have no problem doing that, and ideally we would like to do that. We talked about the completeness of the application, wherein we put together everything. And our firm is ready to start filing the application starting April 1st. So again, the most common question that we get to hear is the fee structure. Our firm is not charging for the pre-registration process. However, the $10 pre-registration is on you. We are not, so while there is no legal fee associated to the pre-registration, there is a USCIS fee that the petitioner would have to bear for the $10. We are not charging for the LCAs to be raised. That is, you raise an LCA in the first week in the month of March and you want to come back and re-raise it, that's absolutely fine, and we are more than willing to oblige this request, and we are not charging for this. The charges for the selected registration will be the same as what you paid last year, or if you're a new client to us, this whatever we have on the contract holds. So we're trying to keep it as simple as possible and not complicate things here. We have half hour, and I am ready to open up the lines for questions if I can. Kaushik, do you think we can open it up?
Sure, the participants can unmute themselves and they can ask the question.
Okay, questions, folks?
Hi Sharda,
Hello.
this is Anu, your person.
You know, how can I help you? Anu, I can't hear you. Anu, you went on mute. Kaushik, do you think we can unmute everyone?
Everyone has been unmuted.
Thank you. Anu, you had a question. Okay. Anyone else? Any questions? Clear as mud, everyone?
Can we file multiple LCAs? Let us say in March we are filing an LCA, and but we have time till June this time. So let us say the project is going to be completed in May or starting of June. So is it okay for us to file a new LCA
Absolutely.
before we?
Absolutely. But the only thing that we can't do is we can't swap it out, right? That is, you send in the application and then you realize you want to file a new LCA. That cannot be done. But if you have not sent in the application to USCIS, you can file a new LCA and file it. That's okay.
Thank you.
Yeah, I had just one quick question. I wanted to ask that, if we hello.
Hello, I can hear you.
Okay, so I wanted to ask if you would be able to know, the people for whom, would we get a receipt for whom we have done the pre-registration? If our employees, they want to know if we have actually done the pre-registration or not. So can we show them, or would we get a receipt kind of, I'm not receipt, but then after we complete the pre-registration, can we get a confirmation or something like that?
Technically, USCIS is supposed to be sending a confirmation saying these has been accepted. The method of communication is unknown to us right now, but you would be able to see it on the USCIS portal whether it has been submitted or not, because the name would be clearly shown.
Okay. Okay.
I have a quick question.
Uh-huh.
So we need to file LCA before March 1st?
You would not be able to file the LCA before March 1st, and here is why. You can file the LCA only 180 days ahead of time. So typically March, 180 days ahead of time. So because you need to have the LCAs available from October 1st, before March 1st is too many days before, more than 180 days ahead before March 1st, October 1st. So you won't be able to do it before March, but in March you can file the LCAs and have it ready.
Okay, thank you. Thank you so much.
Anything else, guys? Any questions? So I have a question here that is from Sampurna that goes, we know that employees go for employer shopping to do duplicate filing. How does pre-registration impact on the duplicate filing? So this is how it will impact. So let's say the beneficiary files from two different petitioners. So you file from ABC, he files from ABC, and he files from XYZ. Both are picked. Then the beneficiary, unfortunately, will have the preference to say whom he is going to go through. And suppose he says, I'm going to file it through ABC, then the XYZ person and doesn't may need to have a reason as to why they did not file. So that's where the problem would be. Does that make sense? Prasad, you're speaking, but I can't hear you. Any other question, folks?
What's the process for registering the HR email ID in the USCIS website?
If you go to uscis.gov, there is a link for online filing. You would be able to register yourself there. But what we will do from our side is we will send an email with all these details as to where the link and all the details, so that you have it handy when you're trying to register the HR's email ID.
Thank you, Shraddha.
No problem. Any other questions?
Hi, ma'am. This is Bhaskar.
Hi, Bhaskar sir.
Yeah, ma'am. Actually, as previous call, you told you explained regarding the when we file when we pre-register for the few applicants for our employees, and when we file for the employees from the India. So, for example, if you file like few applications from India and they got picked up in the lottery, and for some reason they went with another employer. So as you told before, like the USCIS will come and they will ask us why didn't we file the application for the few applicants. So when they got picked up, so what's the reason we need to tell for them, like regarding the employees, like regarding the applications we filed from India?
Got it. That's a very good question, sir. So you may want to consider having an employment agreement signed and kept it prior to March 1st from these beneficiaries, which are dated. So in case they don't file through you, at least you have evidence to show that, hey, there was an employment agreement between us for them to join us, and they backed out. And also, if they say they don't want to file, have it documented in some form of an email or a written communication that you can show to say, okay, we intended to file, but the person did not join us, so we couldn't file. It's more paperwork.
Okay, ma'am. Got you.
Anything else? No questions? All right. If not, I am more than happy to give 20 minutes back in your lives. Let us know if you have any questions. Our email ID and phone number is available in this presentation, and I'll talk to you all soon. Thank you so much.